amendments to the Code of Criminal Procedure Act and to the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment Act and certain orders for approval. I must thank the Honourable Minister for remaining in the House after presenting these bills and listening to the various comments that are being made on this matter. The matters that have been placed before the House are very, very important and serious in nature. What we see in the amending act, in both the amending bills, we welcome, because it seeks to make it obligatory on magistrates to visit police stations, and if I heard the Honourable Minister right, not just the police stations but also other detention centres, and examine and see whether the detainees are properly treated, particularly with a view to ensuring that there is no torture or other cruel, inhuman or degrading treatment meted out to them. So, on paper, it's a good move. But one wonders why this window dressing is being made now. If any of us who are aware of the actual situation with regard to torture in this country would wonder why this amendment is being placed today. So much for shouting from the rooftops that we are protecting our sovereignty, we are not bowing down to international pressure and all of that. But all of these facades are being built, and I don't know who you are trying to fool. The Convention Against Torture and Other Cruel, Inhuman, Degrading Treatment or Punishment Act was passed in 1994. And we have various researches that have been made with regard to the efficacy of this act. 26 years of this act has seen just 9 convictions, 6 of which are under appeal. Very recent research publication by Law and Society Trust says that there were only 47 prosecutions. Only 47 prosecutions. Less than 0.1 of the complaints that are made. And one knows that even the complaints are only about 10-20% of the actual happenings. For various fears of reprisals, of further mistreatment, of family members being put in jeopardy, all of those, and only about 10 to 20% actually make the complaint. And I just worked out the figures. This act in operation has been a dismal failure. The calculation, a very generous calculation, will show that only 0.06% of the complaints result in any conviction. Now, how is that to be compared with Article 11 of the Constitution. Article 11 of the Constitution and Article 10 of the Constitution are two provisions that can't be abridged, that can't be restricted. Not by law, not by anything. But we have a situation in this country, time and again, we have judgments from the Supreme Court finding police officers guilty of torture. There are judgments written. Honorable Minister of Justice, being a lawyer, knows that very well. Every volume, every single volume of law reports have judgments of the Supreme Court finding police officers guilty of the most inhuman methods of torture. But they are not brought before court. You have this act to show people around the world that torture is an offense. Today you are even enhancing the fine. What for? You don't prosecute them. Why did you waste this paper? Put it before Parliament. You don't prosecute them. Right? This is to show others. That's why I called it a window dressing. Already, over 100 years, the prison ordinance requires the magistrates to visit the prisons. Do they do that? When did the last time a magistrate visited a prison? I'm asking this question from the Honourable Minister because you may put it here, making it obligatory, that's salutary. How are you going to enforce this? How are you going to enforce a magistrate to visit police stations and other detention centers? Is there a mechanism here to do that? No. There is no mechanism. You already have for 100 years. I have known one or two magistrates, conscientious, have gone and visited prisons, but they don't do monthly, they must do that. They don't do that. And everyone knows that. No mechanism to enforce that. But even if you have a mechanism to enforce that, if the magistrates are not conscientious enough to do what the law has required them to do, can you by force have them do that? No, you can't. Once a special rapporteur of the UN on torture, remember his name very well, Manfred Novak, came and visited places of detention. He was an expert in the field. You must read his report. I think that report came about 15 or 20 years ago, but still valid because he visited a particular place. Then later in the afternoon, he visited the place again. And he found people who were there, not there in the morning, they are in the afternoon. He put it all down because those who had been tortured had been taken away and hidden when he went there announced. So he went unannounced in the afternoon and found them. All of those facts are there. Later there is another rapporteur, Mendes, who's given another statement, a report. You allow them to come to this country because you want to show the world that you are open, right? There is no torture. Sri Lanka is one of the worst countries for torture by the police machine. I'm happy that the Minister of Public Security is also here now. We are one of the worst countries. You can say this, you can present this. I heard the Minister say, buildings, hardware, the laws that you have passed is software. And he thinks that that is complete. But where is the delivery? You have made the computer, you have programmed it, but doesn't work. It doesn't work. Even the power doesn't come on in your hardware and your software computer. Right? It's broke. The system, insofar as torture is concerned, your system is broke and you can't fix it by passing these laws. Now, one word about Prevention of Terrorism Act. Torture in this country became an epidemic because of the provision in the PTA that enabled, that allowed confessions made to police officers as admissible evidence. That's how torture became endemic. That's how police officers lost their ability to investigate offences. They no longer had to investigate offences. That skill disappeared long ago. All you had to do was beat up a fellow, or do worse, get his signature. You solve the crime. I have demonstrated, I don't want to repeat this, I have given stories after stories after stories where crimes are supposed to have been solved because you have a confession. You convict the wrong person. But what is dangerous in that is that the real culprit is still roaming free, is still there out on the street. That is what is dangerous about this. If you are only concerned about national security, you say, your national security is gone because the one who actually committed the crime is out there. And you have got somebody else, got a confession and put him behind bars. So even from that point of view, not just from the human rights point of view, not from the human dignity point of view, even from your avowed national security point of view, it's a dismal failure. The European Union has passed a resolution that they're withdrawing GSP+. Why? Because in 2017, a guarantee was given by the then government that they will repeal the PTA and replace it with another law that is compliant with international human rights standards. Some effort